In this video, we develop a model that we can use to assess the incentives for precaution from various tort liability rules. We then apply our model to the rules of strict liability and no liability. Accidents can impose costs on society through two basic means. One, the direct cost of an accident due to the harm when an accident actually takes place, and two, the cost of taking precaution to avoid accidents. The social cost of accidents is given by this equation. W is the cost of a unit of precaution. There is an opportunity cost to taking precaution. For instance, driving slower may lower the probability of being in an accident, but the extra time spent driving could have been spent doing something else. For a pool owner, marking pool depths and posting warning signs and stocking the pool deck with life-saving equipment may lower the probability of an accident in the pool, but these also use scarce resources. X is the units of precaution. P of X is the probability of an accident. This probability declines with precaution. And A is the monetary cost from the harm from an accident. Another variable we will often consider in our model is damages, which is denoted with the letter D. We usually set damages to be equal to the cost of the harm from an accident, which is A. Let's graph the social costs of accidents. We want to choose the level of precaution that will minimize the expected social costs of accidents. Units of precaution are on the horizontal axis. The green line shows that as we take more precaution, the cost of precaution increases. Again, an example of this could be a driver giving up valuable time to drive slower. The slower she drives, the more time she gives up. The yellow line shows the expected cost of the harm from an accident. This is the probability of an accident times the cost of the harm of an accident. Since the probability of an accident decreases as more units of precaution are taken, this line slopes down. The pink line is the sum of the other two. It shows the social cost from accidents, the expected cost due to the harm of an accident and the costs incurred from taking precaution. The optimal level of precaution takes place where the social cost function is minimized. At this point, the slope of the social cost line is zero. In other words, the derivative of the expected social cost function with respect to units of precaution equals zero at the point where social costs are at their minimum. Taking the derivative of the expected social cost of accidents function, we get equation 1. When this is equal to 0, the optimal amount of precaution x star is being taken. Moving the second term to the right side of the equation gives us equation 2. The left side of equation 2 is the marginal social cost of precaution. The right side of the equation is the marginal social benefit of precaution. So at the optimal level of precaution x star, the marginal social cost of precaution is equal to the marginal social benefit of precaution. Now we want to use our model of social costs of accidents to see the effects of different liability rules on the incentives for optimal precaution. In this video, we will assess the incentives for optimal precaution for a no liability rule and a strict liability rule. Let's first look at the incentives for a no liability rule from the victim or plaintiff's perspective. Under a no liability rule, the victim bears all the expected costs of harm from accidents. So for the victim, equation 1 is the expected cost of an accident. It shows that the victim incurs costs from taking precaution and from the harm of any accidents that occur. Solving for the level of precaution that minimizes this function gives us equation 2. Here we see that under a no liability rule, the victim has incentives to take precaution up to the point where the marginal benefit of precaution is equal to the marginal cost of precaution. That is, the victim has incentives for efficient precaution. Now let's look at the incentives the injurer or defendant has to take precaution. Under a no liability rule, only the victim bears the costs from harm when an accident occurs. The injurer escapes all liability. So equation 3 shows that the injurer will only bear costs if she takes precaution. For this reason, the injurer will minimize her costs by taking no precaution at all. Under a no liability rule, the injurer has no incentive to take precaution. This may or may not be efficient. If the optimal level of precaution for the defendant is 0, and it only makes sense for the plaintiff to take precaution, then a no liability rule may make sense from a social perspective. No precaution on the part of the injurer can be efficient. Now let's look at the incentives for precaution under a strict liability rule. Under a strict liability rule, breach of duty does not have to be established for the injurer to be legally responsible. Only harm and cause need to be established. Under a strict liability rule, the injurer bears all the expected costs of harm. Equation 1 shows the costs of accidents for the injurer. It shows that the injurer incurs costs from taking precaution and from the harm of any accidents that occur. The injurer bears costs from the harm of accidents that occur because she is legally responsible to pay damages to make the victim whole. Solving for the level of precaution that minimizes the cost of accidents gives us equation 2. Here we see that under a strict liability rule, the injurer has incentives to take precaution up to the point where the marginal benefit of precaution is equal to the marginal cost of precaution. That is, the injurer has incentives for efficient precaution. Now let's look at the incentives the victim or plaintiff has to take precaution. Under a strict liability rule, only the injurer is held liable when an accident occurs. The victim escapes all liability. The injurer is required to compensate the victim with damages equal to the cost of the harm of the accident. So D, the compensation that the victim receives, is equal to A, the cost of harm from an accident. For this reason, the victim's cost due to an accident simplifies from equation 3 to equation 5. Equation 5 shows that after the victim is compensated with damages, the only remaining costs are the costs of taking precaution. These can be minimized by taking no precaution at all. So under a strict liability rule, the victim has no incentive to take precaution. Both strict liability and no liability rules only give one party incentives to take precaution. That is, these rules create incentives for unilateral precaution. This can be efficient if only one party can reasonably take precaution. Strict liability is generally used in torts dealing with the transportation of hazardous materials and animal attacks. For both of these, it only makes sense for the injurer to take precaution. The efficient level of precaution for the victim is none at all. For instance, what type of reasonable precaution are people supposed to take to guard against the possibility that a tiger escapes from an exotic feline rescue center? Precaution that the general public might take is to avoid being near the center or possibly carrying a weapon. These sorts of precaution are probably not reasonable. So tort law will require the rescue center to pay damages to make any victim whole, regardless of whether the center had breached duty. This application of strict liability rule gives the center incentives to take precaution and gives the general public no incentive to take precaution, which is efficient. The same logic applies to transporting hazardous materials by truck. There is no reasonable precaution that other drivers and pedestrians can take. As the truck transporting hazardous material drives on the highway or through city streets, it is not reasonable for others to keep distance from the truck that would keep them safe in the event of an explosion. So a strict liability rule is used which gives the transporter of hazardous materials the incentives for efficient precaution and gives the general public no incentive for precaution, which in this case is also efficient.